Okay, so I'm just going to take a minute to introduce you to Will to Give, who's your host for today's event. Will to Give is a charity based in Northern Ireland. We represent over 60 member charities, and our main aim is to encourage people in Northern Ireland to consider leaving a gift in their will. But one of the biggest barriers to doing that is actually writing your will. And we have some of the lowest levels of will writing across the UK. So we hold sessions like this really just to try and inform people about the importance of having a valid and up-to-date will. And this session is particularly aimed at people who have maybe a family member or themselves a diagnosis of dementia, and what that might mean in terms of writing your will. So we are very, very lucky to have along with us today Michael Graham from Cleaver Fulton Rankin. So I am now going to hand over to Michael, and I'm going to manage his slides for him as we go through. So Michael, you're very welcome. Thank you for joining us this morning.
Thanks and good morning. Can I just check on a point of housekeeping, as they call it? What signal would you like me to give you for the changing of the slides?
Can we do a Chris Whitty? Next slide, please. Hopefully I'll be able to follow along with you, but just give me a nod and I will change slides.
Sure. Well, I suppose just for those that don't know me, I basically am a private client solicitor, and that means something to other lawyers. It doesn't always mean something to the general population at large. And so what I deal with primarily are wills, estates, trusts, tax, issues around care and protection, so incapable adults, etc., and all of the various bits and pieces that go along with that. So that's essentially what private client work involves. So what I want to talk to you about today really is kind of will planning, estate planning, because that's also a very large part of what I'm doing with clients, is trying to come up with an overall strategy for where their estate is now and where they want it to get to. And so I want to look at those issues really with a view to issues around dementia and care as well. So that's the plan. There is a list of the kind of the key topics we're going to look at. So I'm going to talk a little bit about wills and the importance of them. So the risk of having no will is that you die intestate, and that means that your estate basically gets wound up in accordance with legal rules that are already set out in statute. And it is the Administration of Estates Act 1955 which deals with that. Now, if you look at the date, it's obviously not recent legislation. And although the various thresholds that I'll mention in a moment have changed over time, the basic arrangements have not changed. So essentially it aims at the nuclear family. If you have sort of more interesting or unusual circumstances, then the insolvency legislation, or sorry, the intestacy legislation will not work particularly well for you. If you have a simple kind of nuclear family arrangement, it might be okay. But again, you're entirely reliant on the general law. So the rules are that if there's a surviving spouse, he or she will take the first £250,000 worth of solely held assets. Anything which is held jointly as joint tenants would be surviving spouse, absolutely. And that does not form part of this total. So, you know, again, for people who've got fairly modest estates, it may not be as much of an issue, but that's the threshold, 250,000. If there are children, the residue then is divided between the spouse and the children. And it depends on how many children there are as to how that split works. Basically, one child, it's 50-50, two children, it's a third to the spouse and 2/3 to the children. If there are no children, then the threshold does go up to 450,000. But in those circumstances, the deceased person's parents may take a share if they're still alive, or either of them. Or if the parents have died, then the siblings would take a share. And you can understand how that can lead to all sorts of unfortunate outcomes, because a lot of the time people don't get on terribly well with their in-laws. And when you add in a bereavement and money to the situation, it can become an awful lot worse. The absolute kind of worst case scenario, and I have to say in 20 years of practice, I've never had an estate where this is the case, but it is theoretically possible, If there's no family who survive under the terms of the rules of intestacy, then the whole estate would pass to the Crown. That's what's called bona vacantia. And it's basically, when you think about it, 100% inheritance tax rate, because everything that you have would go to the Treasury. So the point I'm making is that really, in some circumstances, intestacy might just about serve a purpose, or the rules thereof might serve a purpose, but generally, they're not going to completely reflect anyone's wishes. Slide. So having said that, I think really we can agree that everybody should have a will in place. What I'm now going to say to you is that a basic will is probably also insufficient in many cases. And by basic, I mean the kind of typical arrangement that you would see commonly, where someone will leave everything to their surviving spouse, and then on the second death, they would leave everything to their children in equal shares. Sorry, can I just say there's somebody who doesn't have their mute on, and there's quite a bit of feedback that I'm getting. Is there any chance I could just ask everybody to mute themselves? Thanks. So the point about the sort of will that you would need is it will depend upon your individual circumstances. Really, a will needs to be bespoke in that sense. So first of all, you'll need to consider a number of things. This list that I've provided on the slide is not in any way comprehensive, but it is, a sort of a ready reckoner of things that you might want to consider. First of all, who should benefit? And when I say that, really what I mean is, who do you have an obligation to provide for? And in particular, there is this piece of legislation called the Inheritance Order 1979. And in very simple terms, what it says is that if there is someone who is dependent upon you, now that could be a minor child, it could be a spouse, it could be an adult child with a disability, it could be, Auntie Agnes, who you've been paying the care fees for some reason. But if somebody has got a financial dependency upon you and you don't provide for them in your will, then there is a possibility, and certainly in the case of spouses and minor children, a very high likelihood that there will be a claim against your estate whereby the court will order that reasonable provision be made. So it's all very well thinking that you're going to disenfranchise the spouse that you can no longer stand and you want to leave everything to the cats and dogs home. But unfortunately, the legislation is in place to prevent that from working. So you need to think carefully about when you're drafting your will, you need to think carefully about avoiding future prospective claims against your estate, particularly under that sort of legislation. Now, that's a rather extreme example. What we're more regularly concerned about is protection. And by protection, what I mean is making sure that if you leave assets to a particular beneficiary, you're not going to end up with that beneficiary losing the assets because of some financial misfortune. So really what I'm thinking about here are things like with a surviving spouse, if you leave everything to them and they go into nursing care, well, potentially everything that they've inherited from you will be made available to pay for care fees. If you have a beneficiary who suffers from a disability and is in receipt of means assessed benefits, then leaving them an inheritance would disqualify them potentially from those benefits. If you have a beneficiary who maybe has a drug or alcohol problem, then leaving them a large inheritance is also unwise and liable to exacerbate the problem that already exists. So in all of those circumstances, we would be looking at some other kind of arrangement, normally a trust arrangement, and I'll come back to that issue in due course, but it is primarily a protection point, either protecting the beneficiary from themselves or from the financial claims of others. The other thing that we also would be concerned about all of the time when we're preparing wills for clients is the taxation implications of what we're doing. As I say, I'll come back to that also in a bit, but in general terms, what we're trying to do is make sure that a will is as tax efficient as possible. What we don't want to do is create a tax problem where none had existed previously, or fail to maximize available exemptions. So where we know we've got exemptions that we can claim and use, we want to be able to use those. There are things like the residence nil rate ban for a main residence, which I'll come back to in a bit. There's ways that you can leave that tax efficiently, and there's ways that you can leave it inefficiently. And obviously we're going for the former. You also need to think about your choice of executors and trustees. Those are the people who will administer your estate and deal with any trust that you leave in the will. It is often tempting to just appoint family members. Often the beneficiaries of the will may be the executors of the will, and there is a certain simplicity to that. But if you have a trust where there's any kind of discretionary power, then that can be unwise. You may need to think about having either a professional executor or trustee, or even just a trustee who is not also a beneficiary. So perhaps a different family member might be a good choice. But all of these things need to be considered depending on what the terms of the will ultimately will say. But the final point on the slide is you need to consider the range of possible situations that can arise, because even if you make a will today that's good for today, if your circumstances do change, and sometimes people's circumstances can change dramatically in a very short period of time, then that is usually a trigger to review, update, and amend any existing will. Slide. Now, again, just with an eye on the issues around capacity and dementia, I thought I would just mention statutory wills, because a lot of people don't know about these, and indeed some lawyers that I have encountered don't seem to know much about them either. So worth a quick mention. Basically, if somebody has lost their testamentary capacity, so they're not able to make a will because of illness or some other reason, it is possible for a will to be made on their behalf. And what happens is generally an interested party, so a family member, or if they're subject to some form of financial controllership or power of attorney, it could be the person who is their controller or attorney. But someone will make an application to the court, basically to say that if this person was capable, they would wish to change, or indeed put in place, if they don't have a will, new will arrangements which do whatever we think is most appropriate in the circumstances. And it can be done for various reasons. Most often we do it for really estate planning reasons. So to minimize care fees on a second death, to perhaps make a will more tax efficient if it's inefficient. But generally the issue is whether or not this is what a will that person would have made if they had regained their capacity for a brief period of time. It's what is known as a substituted judgment test. So the court effectively stands in the shoes of the person and says, is this a will that they would want to make? And that's obviously done on the basis of evidence. We submit to the court a summons and affidavit and a draft of the will that we want. And the master of the Office of Care and Protection, who is the judge responsible for these applications, will then make a decision based on the merits of the case. People tend to get very worried when I talk about making applications to court, but very often statutory will applications, and indeed controllership applications, which we'll look at in a bit, those tend to be done on the papers, as they say, so without the need for a formal hearing. There is a bit of cost involved, undoubtedly, but it's not the most complicated of applications. It would be difficult if you were making an application for a statutory will which was designed to cut a beneficiary out or something dramatic like that, because in those circumstances, the master would almost certainly direct that there should be a hearing and that the person affected by the change would have a chance to make representations. But if the beneficiaries were unchanged at the end of the day and all we were trying to do was achieve a more tax efficient result, for example, generally that goes through without any formal hearing being required. So a useful way to remedy the situation if somebody has lost capacity and we really would like to amend the terms of their will. Slide. Another thing which is quite crucial, I think, particularly when you're concerned about issues of capacity and dementia, is to have an enduring power of attorney. Now, my own firm's practice is to recommend to any client who's making a will that they should also make an enduring power of attorney at the same time. And you'll see from my slide that that is also the recommendation of the Society of Trust and Estate Practitioners, which is basically an international organization of people who do this sort of work. The reason for that is that people tend not to come and see a solicitor about making an enduring power of attorney as a standalone piece of work unless something has already happened. So that's the classic phone call would be, mum has dementia, she's got much worse, is it possible for her to sign an EPA? And the question then will be, well, how bad is she? And often there needs to be a medical assessment, and it can become difficult. And sometimes the answer to the question is, well, she's just not able to make the enduring power of attorney. So ideally, you would be doing this at a time when you are healthy, capable, and everything is fine. And I tend to think of enduring powers of attorney as a little bit like an insurance policy. You make them when everything is okay. You hope that you never need to call upon it. But if something should happen, then it is there and it's available. So what do they do? Well, basically you can appoint somebody or a number of people to manage your financial affairs in the event that you become incapable of doing so yourself in the future. It is only for financial affairs. We don't yet in Northern Ireland have the facility to make a power of attorney that governs health and welfare issues. So decisions about medical treatment and that sort of thing. That is on the way with a new system called the lasting power of attorney. The legislation for lasting powers of attorney has already been passed by Stormont back in 2016, but it has not yet been implemented. So we kind of wait for that with bated breath. But for now, the only thing that is available is the enduring power of attorney. And that, as I say, is financial affairs only. But they have the advantage, I think, of being quite inexpensive, particularly compared to the price of lasting powers of attorney, as we've seen in England and Wales, where the legislation has been in force for some time. So my advice to anybody would be to make an enduring power of attorney now, even if the lasting power system is ruled out soonish. All enduring powers of attorney will continue to be valid, so you don't lose anything, and you can, of course, decide if you wish to change or upgrade, if that's the term, to a lasting power at some later stage, if you prefer. But certainly, I have seen them prove their worth because they certainly streamline the management of somebody's financial affairs. The alternative, if there is no power of attorney in place, is to apply for controllership, which again is a court application, tends to be much more expensive than just registering an enduring power of attorney, and also requires the court to have an ongoing sort of supervision of your affairs. Slide. So to say the lasting powers of attorney are on their way. I've probably covered that off already. I'm also going to mention living wills. Again, partly because we don't yet have the health and welfare element of lasting powers of attorney. A lot of people, or a certain number of people, are quite interested in living wills. Now, a living will is sometimes called an advance directive. It's a document in which you can set out in detailed terms what you would and would not be prepared to accept in terms of medical treatment if you were unable in the future to give or withhold your consent. So it's not the same as a health and welfare lasting power of attorney, where you would effectively appoint a person to make those decisions on your behalf in conjunction with the medical team. It's where you're really just setting it out in advance as to what you want to do. Now, some people have concerns about living wills because they think it's perhaps an argument for euthanasia by the back door, and also you're making decisions at a time when you're generally in good health and deciding them about a point in the future when you would be in poor health, and arguably you might change your mind. You know, if the wolf was actually at the door, would you still want to go through with it? And that's a question that can't be answered if you've lost capacity. But certainly, if you have strong feelings about particular medical treatments, it is something that you could consider having. And of course, it's important, having made a living will, that you make sure that your GP has a copy of it, that your family know your wishes, because obviously if you were rushed into hospital for some sort of emergency treatment, the medics need to be able to be made aware of what your wishes are. But they do certainly have a value. Slide. So I touched on controllership. This is what you've got where you don't have an enduring power of attorney. So the person in question has not signed an EPA. They then become incapable of managing their financial affairs. And again, as with the power of attorney system in Northern Ireland, controllership is purely financial. The new system that introduces LPAs to Northern Ireland will also introduce a system of deputyship, which will allow people to be appointed by the court to take health and welfare decisions. And I should say, in that respect, when we're talking about somebody taking health and welfare decisions on behalf of another person, it's not just as simple as saying, well, I've decided to turn off mum's life support machine. I mean, it doesn't work like that. But that person, the attorney or the deputy, will in due course be the person who the doctors are discussing treatment with. And that person will have a role to play, but not an absolute decision-making role. But at the moment, a controller appointed by the court would only be able to deal with the financial affairs. As I said, the big difference between controllership and a registered enduring power of attorney is when you are an attorney acting under a registered enduring power of attorney, although the court has been told that this system is in place, that this person has lost capacity, once the thing has been registered with the court, the attorney can then just do really whatever needs to be done. They've got complete flexibility. With controllership, it is literally a case of you can only do what is on the controllership order. So you will apply to the court will say what the patient requires based on your application. The order that is made will then tell you the things that you can do as controller. And if you then discover there's something that's not on the list that you need to do, you have to go back to the court and get a further order. I mean, just by way of example, I recently had a letter from the court giving off about my client who had closed a bank account. Sorry, that's not true, wrong, had moved money from one bank account to another without getting their prior approval. So it is as strict as that they want to know every single step that you're going to be taking on behalf of the patient. Whereas with an EPA, none of that applies. There's also an ongoing fee that the court charges for monitoring what the controller does. So all in all, it's certainly a system that has a lot more scrutiny. If you are the sort of person who likes the thought of that, then maybe controllership is for you. If you prefer that a family member has the flexibility to act as they wish, then definitely an enduring power of attorney is preferable. And certainly that would be my view. Slide. Now, I sent these slides to Claire at the end of last week, and I did say, I hope this isn't too long and boring. So on that basis, I'm not going to spend too much time on inheritance tax, but I'm going to do a very quick canter through it because I think it's useful. The point that I would always make to anybody who's involved in the world of estate planning or will preparation, whether that be a client or a new lawyer, a newly qualified solicitor, is you simply cannot advise on a will at all unless you have an understanding of inheritance tax and how the system works and whether a person is going to be subject to inheritance tax on death or not. And there are a lot of variables here, but in very general terms, we all have got an allowance, which is called the nil rate band, and that's 325,000. Okay, so that's the amount that you can always leave on death without tax being payable. Now, married couples have got one each, obviously, and since 2007, those have been transferable. So if I pass away, leaving everything to my wife, when she dies, she has 650,000 at current rates. It's basically a doubling. She will get twice the available nil rate band on her subsequent death. Now, over and above that, the balance of the estate is chargeable at 40%. However, if you have children or other descendants, and that is quite a wide term. It includes stepchildren, it includes foster children. But if you have got somebody who qualifies as a descendant for inheritance tax purposes, there's also a thing called the residence nil rate band, which you'll see at the bottom of that slide, which is currently 175,000. And that applies to any property that you leave to the descendants. And it has to be subject to some restrictions or provisos. It has to be left to them on an outright basis. So they must take an absolute entitlement in that property or a share of it up to that value. But if you have a property that is worth at least that, so let's say you've got a house, you and your wife own a house that's worth 350,000. Well, your residence nil rate bands will cover that property as long as it's left to descendants. And the rest of the estate can be worth up to 650,000 before tax would bite. So that is really up to £1 million worth of exemptions. Now, I understand that for the vast majority of people in Northern Ireland, that is taking them out of the inheritance tax net, and that's great. But obviously for people who are wealthier, for people who don't have children, for people who maybe are unmarried, then inheritance tax can be a real issue. So there are a number of other exemptions that I'll just flag up there. Spouse exemption, obviously anything that you leave to your spouse is completely free of tax. The charitable exemption currently still applies to any UK or EU charity, but I'm always curious to know when that EU element will disappear, since we have now left post-Brexit. But certainly if you're leaving it to a local or UK charity, it's 100% exempt. There's an annual exemption which applies to lifetime gifts. So you can give away £3,000 a year, and that has no inheritance tax implication at all. You can also make gifts on marriage, the closer the relationship that you have to the person who's getting married, the larger the gift. So you can give a child £5,000, you can give a total stranger £1,000. There's a small gift exemption, really designed so that you don't end up having to, record and report every Christmas or birthday present that you give to someone. But those are all quite modest amounts, and although they have their place, they don't really make a big difference to somebody's overall inheritance tax position. The two at the bottom, or above the bar, but at the bottom of the main slide, are the two, I think, which are quite interesting. The first of those is normal expenditure out of income. So basically, if you have a good amount of income, a large amount of surplus that you don't spend each year, you can give that away in its entirety, year on year, completely free of inheritance tax. Okay. The normal rule, which we'll look at the next slide, is that there is a clawback on lifetime gifts. But if the gift has come from your surplus income, then there is no clawback. And all you have to do, or all your executors have to do in the event of your death to claim that exemption, is to demonstrate that there was a pattern of gifting. And the revenue accept that even 2 years in a row of gifts from income would establish a pattern of gifting. You could even argue if you did it in a single year, but certainly 2 years would establish a pattern, I think, beyond any doubt. And the last point on the slide there is APR, BPR, that is agricultural and business property relief. So if you happen to be a farmer, or if you happen to own agricultural land, which is being used for agricultural purposes, even if you're not farming it yourself, then you can get 100% relief on that asset or those assets. In addition, if you own a business and it's a trading activity that you're involved in, you can also have up to 100% business property relief on those assets. But further even than that, there are certain types of investments that you can buy just as a non-business owning layperson, which themselves qualify for business property relief. And generally those are shares listed on the alternative investment market. So sort of higher risk shares in smaller startup and sort of medium-sized companies that qualify on the AIM market. And there's a lot of providers out there, financial providers, who basically package together bundles of those shares that you can buy into with the aim of getting a business property relief on the investment. The requirement for both agricultural and business property relief is that there is a minimum qualification period of 2 years. So you have to own them for at least 2 years in order to qualify. And in the case of agricultural relief, if you're only letting the land out to a farmer and not farming it yourself, the qualification period is actually 7 years. But either way, those are valuable reliefs because they are, as I say, 100% in value. So I do have clients, for example, if they have assets in excess of £1 million, they know that they're covered by those other exemptions that we've already looked at. They may choose to put a portion of the excess into a business property type investment in order to bring down the chargeable estate, sometimes to zero. Now, that's obviously a financial advisor's job to assist with all of that, but certainly it's useful, I think, for you to know. Slide. So the one that I really want to flag up with inheritance tax that you'll all have heard of, even if you don't know the name of it, is the potentially exempt transfer. And that's the 7-year rule. Every person that I've ever met in the course of my job knows about the 7-year rule. What you need to understand is it does not apply to anything other than inheritance tax. So for example, the common error that I would hear is if I sign my house over to my children and then live for 7 years before I go into a care home, the health trust can't touch my house. Well, that's not correct because the 7 years doesn't have anything to do with the rules relating to care fees. However, there are arguments we can look at in a minute about that, but it certainly is not a hard and fast rule. It is purely for inheritance tax. So how it works is if you make a lifetime gift, and if you think about it, it's really anything in excess of the annual exemption that I mentioned. So the £3,000 that you can give each year. Let's say I make a gift this year of £100,000. What I've really done is I've made a potentially exempt transfer of £97,000. If I die within 7 years of that gift, you have to add that value back into my estate in order to work out what my overall tax liability will be. Now, if adding it back still has me under the threshold, there's obviously no tax to pay. If it puts me over the threshold, then there may well be some liability. If you live for the 7 years, then it just drops out of account and it's as if you never had it at all. So clear enough. However, there is one particular fly in the ointment, and that is the rule on what they call reservation of benefit, or gifts with reservation of benefit. So if you've made a gift, obviously if you give away cash, that's normally straightforward enough. But if you give away an asset like your house, or a holiday home even, and you don't completely give up your use of that asset. Now, there are variations on this. If the person you've given it to is living with you, for example, there may be ways that it can be structured to be more tax efficient rather. But basically, say I sign my house over to my children, continue to live there, I don't pay any rent for living there, and then die at some future date, the value of the property remains in my estate for inheritance tax purposes throughout. There's no 7-year clock ticking because I've not made a completely arm's length outright gift. And a lot of people don't understand that. Now, there is a double whammy, because the property remains in my estate for inheritance tax purposes because of the rules on reservation of benefit. If the child that I've given it to also then dies when I'm still alive, it's also part of their estate for inheritance tax purposes and would be subject to tax in those circumstances as well. And if the house is sold, because I don't own it, it's someone else that owns it who presumably is not living there, then no principal private residence relief would be available for capital gains tax. The beneficiary who sells it will have to pay tax on any gain from the date that they got it to the date that it's sold. So it is really something of a tax nightmare, reservation of benefit. Now, again, it only matters if you have an inheritance tax problem in the first place, but it is certainly something that people do get wrong, and you see it being done incorrectly quite often. Slide. Now, I just want to mention very briefly lifetime trust. So for planning purposes, it is possible to look at setting up a trust. Now, in general terms, a trust is any situation where we separate out legal and beneficial ownership. So assets are held by trustees, who are the legal owners, and they manage those assets for the benefit of named beneficiaries or classes of beneficiaries. So you would set up a trust sometimes during your lifetime, sometimes under the terms of your will. It would be common to do it for a disabled beneficiary, for example, or to make provision for minor children. But regardless of why you do it, if you were ever to set up a lifetime trust, and this would include even trusts of life insurance policies and things of that nature, if they are what we call relevant property trusts, i.e. really anything other than a very simple bare trust. If you put assets into trust during your lifetime, you can end up with an inheritance tax charge. And a lot of people don't know that that is the case. There is a lifetime rate of inheritance tax, which is 20%. And it really only arises when you put property into a trust. So if I was to put more than £325,000 into trust at any stage in my life, then as soon as I've gone over that 325,000, I'll get a bill for 20% of the excess. And in addition, the trust will be subject to inheritance tax every 10 years and when you make payments out of the trust. So it is something that we do for clients in certain circumstances. Sometimes we would look at trust planning with lifetime arrangements, again, perhaps to plan around nursing care fees, but you're always having to be very careful that you don't exceed that threshold and give yourself an inheritance tax liability. So the key point there is, if you see the word trust, or you're thinking about creating one, or someone's telling you to create one, you do need to get proper legal and often accountancy advice before you commit to it. Slide. I promise I'm going to come to an end of the tax points fairly soon, but I just wanted to mention capital gains tax because, again, it's one of those things. Everyone's focused on inheritance tax whenever they're estate planning. You need to also be aware about capital gains tax issues. So capital gains arises whenever you dispose of an asset, and people often assume that that means sell it, but it's both a sale and a gift. So if I have an asset which is heavily, as they call it, pregnant with gain, so I've had it for a long time, it's worth more now than it was when I bought it. You know, the classic example might be the holiday home, and I decide I'm going to give that holiday home away to my children. Well, when I make that transfer, even though I'm not getting any money in return, I'm just making an outright gift. It's a potentially exempt transfer for inheritance tax purposes. but I have made a disposal for capital gains purposes. And so whatever the increase in value from the original acquisition to the date that I give it away, and it has to be at full market value because I've also given it to a connected person. I've probably given it to my adult child. I will pay tax. And in the case of residential property, I will pay tax at 28% as a higher rate taxpayer on the increase in value, less any personal allowance that I have for the year. Currently, it's about 13 grand. So people often do these things and then don't realize. I mean, I had a very quick example. I had a client a few years ago who came to speak to me about giving a property to his daughter. And I sat and explained all of these problems to him. And he sort of went a funny white color. And I said, you know, what's wrong? You know, are you concerned about this now that I've told you about it? And he said, well, no, I'm more concerned about the other 4 properties that I've already given away. So, you know, he then had to go back to his accountant, that chap, and basically put in amended tax returns for the years in which he had given away those properties. So you do just need to be aware that receiving no money in return is not an excuse for not paying tax. Plus, the rules on residential property have now changed that if you dispose of a residential property, you have to pay any capital gains tax due within 30 days of the disposal. So it's got even more acute. So that's the rule. There are exemptions. Things like ISAs and that certain national savings products are exempt from inherit or capital gains tax. There is an entrepreneur's relief which applies to business assets when you dispose of those, which gives an effective reduced rate of 10%. Not a complete exemption, but certainly a helpful reduction. And the key one that everybody should be aware of is there's no capital gains tax on your main residence, on your principal private residence. So if you own your own home and you've always owned it or always lived in it whilst you've owned it, then a disposal of that would not give rise to a capital gains tax liability. If you've only lived in it for some of the time that you've owned it, then it would be applied on a pro rata basis. So you do just need to be careful about that as well. Some people assume that, you know, if you move into a property, live in it for a bit and then sell it or give it away, there's no tax to pay, but that's not correct. It's only going to apply to the proportion of the time that it was your main residence. Now, there is a thing called holdover relief, which is quite useful. And generally, holdover relief applies in 2 situations. One is for business assets, which isn't that commonly availed of, certainly in my area of work. But the other one is where you use a trust. Can we go for another slide there? Yes. So this is a little diagram just to show what I'm talking about. So there is it's section 260 of the Capital Gains Tax Act. If you transfer an asset into a trust, because that is actually a charge, an occasion of charge for inheritance tax normally, there is an exemption from capital gains. So even if you're not paying any inheritance tax, it's still an exemption from capital gains. So let's say you had a holiday home and it's of modest value. Say it's worth 200,000. Well, because that's less than 325,000, you wouldn't get any inheritance tax liability if you put it in a trust. So we could take that property, put it into trust, pay no inheritance tax, but claim holdover relief from capital gains. So that is where the original owner and the trustees of the trust will agree that they'll hold over any gain. So even though the property is worth £200,000, you originally had it, you bought it for £100,000, but that £100,000 gain just goes into the trust. You don't have to pay any tax at this stage. The gain is deferred, sort of rolled up and deferred. So the trustees would then have to pay tax if they sold it, but they don't have to sell it. It could be left in the trust. Or if it has to be passed out ultimately to a beneficiary, then again, the same exercise can be done a second time and the beneficiary can receive the property with the gain attached. So if it is a holiday home type scenario, that maybe the family member that you're giving it to is going to keep it long term, then that will avoid having to pay any capital gains tax on the gift and everything is just deferred and rolled forward. Now, I should say you have to be careful that the revenue don't regard this as some sort of deliberate, you know, strategy to avoid tax. And if you did it all in one fell swoop, they would almost certainly query it. But it's quite legitimate to do it in stages. You could put it into the trust in one tax year and perhaps take it out the following tax year.
and it's unlikely the revenue would be particularly concerned about something like that. But it is just a way that we can, if you've got an asset that you want to dispose of, but you don't want to pay capital gains tax on, then subject to the value, you may be able to avail of holdover relief through a trust. Slide. So just bear in mind, where you've got capital gains tax issues, you have to watch out for paying a liability when you dispose of the asset, as we've discussed. Some people I've seen doing a swap of properties. So, you've got mum and dad living in one house, you've got maybe one of the adult kids living in a smaller house, and the brilliant plan is hatched that we will swap because mum and dad want to downsize and the adult child wants to move to a bigger house with their family. Again, the assumption that there's no tax issues, well, there would be a stamp duty land tax issue on that, because stamp duty land tax is payable on consideration, and that can be monetary consideration where you actually buy a house, or it could be consideration where you exchange one house for another. So again, something just to watch out for. Bearing in mind as well, if you've given an asset away, even if it was an exempt asset like your main home, where you didn't pay any tax on the disposal, the new beneficiary, the new owner, may well then have a capital gains tax liability if they dispose of it at a later stage. So let's say you've signed your house over to your kids to avoid care fees, and you then live on in that house for 20 years, and then the kids sell when you've died or moved out. Even though you would have got principal private residence relief for that whole period of time, there would have been no capital gains. And indeed, on your death, all of your capital gains get wiped out, and only inheritance tax really is an issue. Because your children have owned it for 20 years, they're going to have a 20-year gain to account for from a tax perspective. So that is a danger. And particularly when you're planning with the main home, you just need to watch out for your own security of tenure. Generally, these things are done to avoid nursing care fees, which I understand the logic behind, but there are difficulties around that from your own perspective. And if you want to get something back, you want to get an asset back that you've given away, that's even more problematic than the tax implications, because once somebody else owns it, you're kind of stuck then with the new status quo. Slide. Okay, so I'm going to just touch very briefly then on a couple of other things, again, that really have a bit of a focus around dementia and care particularly. So where you're dealing with someone who needs to go into care, the first thing to point out is that any assessment of their means to pay should always be secondary to an assessment of what their needs are. And it is possible to get a health trust to provide a written needs assessment to say why it is that they are providing this particular recommended package. Why are you saying mum has to go into a nursing home now? Why can't she stay at home with a package of domiciliary care and my sister looking after 2 nights a week? Those are conversations that need to be had. There's also a thing called NHS continuing care, which I'm not going to go into in any detail. I have for a long time said this is really a sort of a dead duck, the NHS continuing care, because we've never been able to really get it off the ground in Northern Ireland. I am encouraged to see that the older persons commissioner recently produced a report on the very subject and has chastised the local health trusts for not properly considering NHS continuing care. So it may come back, and I may do another talk on it in the future, hopefully in the not too distant future. In very basic terms, what it says, what the rules say, are that if you are sick and you're receiving primarily health care, even if it's in a nursing home setting, then you shouldn't have to pay a penny for your stay in the nursing home, because you have got a primary healthcare need in the same way that if you were in hospital, you don't get a bill for your board and lodging. If you're receiving hospital level treatment in a nursing home setting, that should also be free at the point of use. So the local health trusts have not really covered themselves in glory on this topic, but it looks as if it may be making something of a comeback. So I think watch this space is the point there. What I would say from the English experience, where they're much more advanced in terms of continuing care, you have to be pretty sick. Like, you have to have a fairly complex medical situation before a court would hold that you are in a nursing home with a primary healthcare need. But there will be people who will meet the criteria, and therefore, regardless of how wealthy they are, they would be able to spend however long they need in a care home without having to pay for it. So interesting. Assuming you don't have a primary healthcare need, you're not getting continuing care, then you would generally have to pay for your own care if you have assets in excess of the applicable thresholds. And that is essentially quite a low bar. There's two thresholds, in fact, what they call the upper and the lower. The upper is only 23,250 quid, the lower 14,250. And basically, as your capital gets down to 23,250 and heads towards 14, you're treated as having £1 of weekly income for every £250 of capital. So a calculation is done. But basically, once you hit 23 grand, you would start to get some measure of state support. Now, most of your assets will be subject to the means assessment. So everything that you might expect, savings, investments, and so on. But people are mostly concerned about the house, and the house is generally going to be disregarded if it is occupied by someone who meets one of these criteria on the slide. So spouse or partner, so you don't have to be married, it could just be your romantic partner, it could be a civil partner as well. A relative who is aged over 60 or incapacitated. So that could be, it could be your carer, it could be your adult child. You could be 80, they could be 60, they live with you for the purposes of caring for you. Well, if you go into a nursing home, they can stay on and the house will be exempt from the means assessment. Equally, incapacitated just means somebody who is in receipt of an incapacity benefit. So say you have a 55-year-old son who is in receipt of the personal independence payment and they live with you, then if you go into a nursing home, again, the property would be exempted from the means assessment. Same applies if there's a child under 16 who lives with you and you are responsible for maintaining them. Maybe you have parental responsibility as a grandparent or something for a grandchild. And also if you cohabit with your former partner, but they themselves have a dependent child, then that also is a rather quirky set of circumstances, but that would also exempt the property. So the house will be exempted if one of those people occupies it as a main residence, which, you know, commonly or often will be available. Certainly the surviving spouse or the other spouse is often the main person who will be exempting it from the means assessment. And the health trust has a discretion to ignore any asset if they feel that hardship would result. But I make the point on the slide that I rarely have seen that used. Generally, unless you fall within one of the criteria, then all of your assets will be taken into consideration. Slide. Oh, you've gone too far. It's a difficult one to really advise on, and in fact, you know, it borderline impossible because the rules are very clear. If somebody gives assets away in order to avoid nursing care fees, then the relevant health trust in assessing that person can apply what they call they're deliberate deprivation rules, but they also are what they call the notional capital rules. So basically, if they think that you've given something away, that you've only done that to avoid paying for care fees, they'll treat you as if you still own it. Having said that, there seems to be fairly inconsistent application of those rules. The way the legislation works, if I give something to my children and I go into a nursing home within 6 months of that gift, and the health trust think that I only gave it to the kids to avoid paying my fees, then they can pursue my children directly for whatever it is I've given them. That's within 6 months, or if I do it when I'm actually in care. Outside of that, they have to actually establish, really under the insolvency legislation, that you have done this in order to defraud a creditor. And it will depend very much on the circumstances of why the gift was made and what the intention was. What I say to clients all the time is, do not be afraid. I remember I had a client a long time ago who came to me and said that her previous solicitor had told her that because she was elderly and because she might need to go into a care home, she couldn't give, I think it was £10,000 to her son because it could be a criminal offence. Now that is complete and utter nonsense. Unless you are in a nursing home, you are not obliged to be worrying about a health and social care trust's budget or a means assessment. So if you want to do something for estate planning purposes or inheritance tax planning purposes or whatever, you're free to do it. The point is that if down the line the health trust has a query about something you've done, we can address it at that point. But certainly there are circumstances where the gap between the gift and the care will be so large that it's going to be virtually impossible for a health trust to say this has got anything to do with care fees at all. So certainly don't let that fear put you off. The only thing that would be a criminal offence, I suppose, would be a fraud, whereby you give things away and then lie about ever having owned them. But you are free to dispose of your property as you wish, albeit that may have an implication down the line on a means assessment. If you were trying to consider something like protecting assets for care fees purposes, then you could look at outright gifts. I've said on the slide there, it is also possible to consider putting assets into trust. And there's various ways in which that can be done. But you need to just bear in mind all of the tax issues that we've already touched on. So anything like this really requires pretty detailed and specialist advice before you would commit to anything. Slide.
Just giving you a 5-minute warning.
I saw it. What I like, if it's possible to have a favourite will, and I am sad enough to have a favourite will, then this would be it. It's what we call an IPDI, an immediate post-death interest, or sometimes just a life interest. So if I and my wife own everything jointly, what we can do is we can split the ownership of our assets 50-50. And on the first death, I can leave if I go first, I can leave my half of the house, my savings, my investments into a trust for my wife. If she then subsequently goes into a nursing home, she cannot be assessed on anything that's in the trust that I've created by my will. And also, it will be possible to argue with a health trust that the value of the half share of the house that she still owns is actually worth nil, because under the regulations, there is a mechanism where they talk about the valuation. And if there's no open market value, then the value will be nil. So that works cleanly. It works very well. As long as both of a couple don't go into care at the same time, it'll work perfectly well. And often there is a first death and then a survivor in care. It also is completely unchallengeable by the health trust, really, because there is nothing to prevent me from setting that arrangement in place. And I would argue that it's also perfectly adequate provision. If somebody was to say that I hadn't complied with my obligations under the inheritance order to provide for my spouse, I would say, well, I have, because she's got all the capital, or she's got the house to use. She's got access to the capital if necessary, if my trustees want to give it to her. She's got her own capital, and this has been done for protective purposes. And that kind of will is very simple to put in place, and it works very neatly. Slide. So I think we've probably covered enough of the nursing care. If we just skip on, I think there's one more slide. So really what I want to sort of sum up with 3 minutes left is, what should you be thinking about generally? Well, the key thing is a will. You need to have a good will in place. So if you don't have one, make one. Make sure it does what it needs to do in terms of tax planning, etc., and keep it under review, because these things will need to be changed from time to time as rules and circumstances change. Make an enduring power of attorney, because I think they're excellent. Consider planning using trusts, now, whether that be lifetime trusts or simply the sort of trust that I touched on a moment ago in your will. They definitely have a place, and they do provide a good amount of protection. Anything that you do around this area will also involve getting good financial advice. So I think you need to be getting a financial advisor on board, and in some cases also an accountant, depending on your circumstances. But really, you need to make sure you've covered off all of those areas. Consider your family circumstances and the fact that they will and do change. And the final point there is, if you maintain regular contact with your advisors, so have a decent solicitor, have a decent financial advisor, have an accountant if you need one, and talk to them reasonably often, and make sure that they also talk to each other. And sometimes you can all sit around a table in better times, post-COVID, get around a table and make sure that everybody is on the same page. And I think in those circumstances, you can't really go too far wrong. I think that's it. my usual disclaimer.
Your
Ignore me.
disclaimer.
And then I think the next slide is just my details. And I don't know if we have time for questions, but I think there were some.
Well, Susan had just commented, want to say thank you. She was heading on now. If you do have time for a couple of questions,
Sure.
And people have time to stay on, you can either use the chat function or just unmute yourself now and ask Michael. I have a couple of questions, Michael. Can I start? Just, you know, I've listened to this a couple of times now before, and there's still elements of it that I struggle with. So in terms of a statutory will, what's the kind of time frame for that, especially during COVID times?
Well, good. That is a good question. Well, at the minute, it's hard to keep track. The Office of Care and Protection was dealing only with urgent applications, and I think they still want you to say if your application is urgent, but they're also processing the more mundane. With a statutory will, I would tend to be telling the court, rightly or wrongly, that it is probably urgent, because if it's an elderly person with a health condition and perhaps, you know, advanced dementia, and we're doing something for them, I would want it to be processed within, you know, a few weeks. So 2 or 3 weeks, I would hope.
Okay.
Sorry.
To anybody else? I have another few, always questions for me. Just, it is still possible to write your will during lockdown. You guys are still working. Lots of things have been moved onto platforms like Zoom and Teams to make sure people can still continue to write their will.
Yeah. I think most lawyers are the same. We're trying to have as many meetings as possible by Zoom and similar. When it comes to signing wills, that is still that is a legitimate activity under the current regulations. So clients are free to come to see me to get those signed. I am free to go to their homes to get them signed. But we're generally only meeting clients if we need them physically present for something like a will execution. During the worst of the last lockdown, when you weren't really able to go anywhere, we were getting clients to get their own wills signed by getting their own witnesses. But I was never particularly happy with that. And for any of those clients, we're going back over and getting them to just re-sign things in our office.
Okay.
But yes, I understand most firms are taking a similar approach, where if we can do it remotely, we will. And if we have to meet, then obviously there's arrangements can be made for that.
Okay, excellent. Just another point, we had hoped to have somebody from Alzheimer's Society on the call today. They weren't able to join us, but I just wanted to make you aware of the Alzheimer's Society helpline that's available in Northern Ireland. So the telephone number is 0300 222 1122. It's available on their Northern Ireland section of their website. So if anybody does need help or advice in terms of especially nursing care that Michael had mentioned earlier, and just kind of the process around that, they're a really, really useful point of call to give them a bell. And I think...
Can I just have a quick question?
Yes, of course, Marcus, go ahead.
Hi, Michael, just wondering about letter of wishes and whether that's something that you would advise as well. Is that helpful for people?
So a letter of wishes generally goes, there's two circumstances that we would use it with a will. The common one is if you've got chattels. I don't like to leave personal effects specified in wills because it's very messy. So we would generally say in a will, you know, I leave all my personal effects to be distributed in accordance with any letter that I leave, and then a side letter for that. The other one is if there is any element of discretion in a will trust. So, you know, you might have a discretionary trust, you might have a life interest with overriding powers where the trustees could actually take the interest off the surviving spouse or, you know, alter the term. In those situations, then a letter of wishes is useful. And they'll generally say things like, you know, look after my wife or husband. And then, you know, if she is provided for, consider making distributions to my kids, consider the financial and matrimonial circumstances of my kids. I think all of that is useful. If I'm brutally honest about it, Marcus, most of the letters of wishes that I see clients putting together with my help or by themselves are stating the obvious, but it does no harm.
That's great. And obviously for gifts, I suppose, to charities as well can be helpful for that element.
Well, in terms of what they want to be done with the gift. Yeah.
Or who it may go to even? Is that... Does that give flexibility or?
Well, no, I suppose, so if we are talking about a charitable gift, I mean, if it's a legacy, If it's a legacy in the will, my advice to clients is to leave it for the general purposes. Because I understand it can be difficult if they try to tie it to a particular cause or promotion or whatever.
Yeah.
If the charity or to express just in the will with the wish that it be used for a particular purpose, but make it very clear that it's an expression of wish only. If the charities were potential beneficiaries, say under a trust or something, then yes, you could put that in to your letter of wishes as to how I've included charities as a potential beneficiary. This is what I had in mind.
Yeah.
Although very often the charities are in as a sort of ultimate default provision. I have clients who would take the view, look, the charities aren't really going to get anything unless both my wife and I and our children have all gone. And at that point, they become the default.
Yeah.
And that's normally clear from the face of the will, but you could also clarify it in the letter of wishes.
Okay.
Is that answer? I don't know if that answers your question, Marcus, or not.
No, it does. Yeah, that's
Okay.
great. Thanks, Michael.
If there's no other questions, I'd just like to finish off by thanking Michael for joining us today. And really, again, just for me, this highlights the importance of having that specialist advice. So, even if you choose to go to a solicitor to get support in writing your will, make sure you choose a solicitor who specialises in an area of will writing, just like Michael does. So maybe not somebody who has kind of a broad overview of lots of different elements, but somebody who is it step registered, Michael? Is that the best?
Yeah, I would certainly take the view if a solicitor is a member of STEP, and that's the Society of Trust and Estate Practitioners, then they certainly will either have been doing this a very long time, or if they're newer, they will have had to have sat an exam. They'll have actually done a diploma in wills and estate administration and so on. So I take the view that is, as good or as close to a sort of quality mark as you can get. So I would certainly encourage people towards STEP members. There's plenty of them in Northern Ireland now. It's grown dramatically over the last sort of 15 years. So there's plenty to choose from. And you can go onto the STEP website and search for them there.
Super. Okay, well, thank you very much, everyone, for joining us. And as I said, we've recorded this, so we will make it available hopefully later on this evening or first thing tomorrow. It'll be up on the Will to Give YouTube channel. So thank you.
Thanks.
Thank you.